Hello and welcome. I am Jacob Turner, a barrister based in the UK. On behalf of the UKLFI Charitable Trust, I'd like to welcome everyone who has joined for this event on the legal case for Palestine, a critical assessment. If you want to find out more about the UKLFI Charitable Trust's events and work, including videos of previous webinars and talks, other educational resources, and information on how you can assist and support our efforts, please visit the website uklficharity.com. I am thrilled to introduce Professor Stephen E. Zipperstein as our guest speaker today. Steve has practiced law for the past 40 years and has played very senior roles in the public sector, the private sector, and most recently in academia. Steve is a professor at UCLA and associate director of the UCLA Center for Middle East Development. Steve is the author of two recent and important scholarly books regarding the legal history of the Israeli-Palestinian conflict, both of which he has presented on for UKLFI to great acclaim. His third book, published this month, and which we will discuss today, analyses the merits of the modern-day Palestinian legal case. He previously served for more than 9 years as a federal prosecutor and argued 23 cases before the Court of Appeals. Subsequently, Steve became the chief legal officer of Verizon Wireless and then BlackBerry, in which role he was responsible for the worldwide legal, government relations, and public policy. Steve's new book, The Legal Case for Palestine, combines legal history with an assessment of Palestinian claims over the West Bank and Gaza Strip, the case for statehood, and the Palestinian claims regarding Jerusalem. And what I think is unique about this book is that it combines academic rigor with the clarity and brevity of a highly skilled trial lawyer. Importantly, the book covers the more recent events of October 2023 and the legal war which has been waged against Israel before and since. It is a work which has not just historical, but also great contemporary relevance. There will be time for questions after Steve's presentation, and you're warmly invited to submit those questions by clicking on the button labeled Q&A at the bottom of your Zoom screen and typing into the box which should open. Please could I ask, though, that you try to keep the questions short. I may paraphrase or combine related questions so that we can cover as many points as possible, as I know many people have joined today. Steve, we are thrilled you could join us again, and I'll now hand over to you for your presentation.
Well, thank you so much, Jacob. Welcome, everyone. I'm deeply honored to be invited back. Very grateful to the UKLFI Charitable Trust. I'm going to put my slides up and we will get underway. Right here, the first page, I'm showing you photographs of the two most important international courts on the left, in The Hague, the Peace Palace, the headquarters of the International Court of Justice. On the right, also in The Hague in the Netherlands, the more modern-looking International Criminal Court. And we're going to talk about the way in which the Palestinians have been waging a legal war against Israel for the past several decades at both these courts, and especially in the wake of the Hamas attacks of October the 7th, 2023. I want to begin by making a very simple point, which I'll come back to later in the presentation, and it's this. Back in 1993, September 1993, Israel and the Palestine Liberation Organization, the PLO, entered into the initial Oslo Accords agreement known as the Declaration of Principles, thereafter signing a number of agreements collectively known as the Oslo Accords. And in those accords, the result of robust, vigorous, arm's-length negotiation between the Israelis and the Palestinians solemnly agreed in writing to pursue all of their claims through negotiation, through diplomacy. But before the ink was even dry, the Palestinians abandoned that course of action to which they had committed themselves and resumed terrorism and violence, and especially embarked on a new strategy, litigation, legal warfare, lawfare, if you will, against Israel in the two courts that you see here. And so the purpose of the book that I've just written, which is out this month, is to ask the question, okay, if you Palestinians have decided that you would rather litigate than negotiate, let's examine the strength of your legal case. Do you have a strong case or not? And I conclude for a variety of reasons that they don't. And I begin, of course, as we always should do when we talk about the Israeli-Palestinian conflict, with the relevant legal history. And that takes us back 102 years to 24th July 1922. The Council of the League of Nations unanimously adopting the so-called Mandate for Palestine following World War I. And that mandate, which had the force of international law, began in the preamble by incorporating and adopting the November 1917 Balfour Declaration, in which His Majesty's government agreed that the Jewish people worldwide should have a national home in Palestine. And the mandate further states, and this is incredibly important for today's legal purposes, the mandate says in the preamble, whereas recognition has been given to the historical connection of the Jewish people with Palestine and to the grounds for reconstituting their national home in that country. And that word reconstituting is vitally important. It doesn't say constitute. It doesn't say colonize. It doesn't say coming into somebody else's home and setting up their own country there. It says reconstitute in recognition of the fact that Zionism was the first great national liberation movement of the 20th century. And here you have the international community committing itself as a legal matter to the right of the Jewish people worldwide to return to their ancient homeland and build a country there. And the mandate required Britain to place the country under such conditions as would secure the establishment of the national home in Article 2. And really important in Article 6, the mandate required Britain to facilitate Jewish immigration and to encourage settlement on the land by the Jews. And here on this chart, I've simply racked up for you side by side the various elements of the Palestine Mandate. Remember, it's a legal document. The Jews were granted a broad range of political rights, political representation, rights to a national home, rights to immigration and land acquisition and settlement. None of those political rights were granted to the local Arab population. The local Arabs were granted religious freedom, of course, and other civil, non-political rights and control over the Muslim shrines. And so the mandate, on the one hand, granting political rights to the Jews to establish a state of their own in Palestine, no parallel political rights to the Arabs. Why? Because after World War I, there were other mandates created for Lebanon, for Syria, for Iraq, and for the future Arab presence, not through mandate, but otherwise in Saudi Arabia. That was the recognition of Arab self-determination, but not in Palestine. And if you don't believe me, everyone, let me refer you to the testimony of the Grand Mufti of Jerusalem. You see him there on the left, Haj Amin al-Husseini, testifying before the British Shaw Commission of Inquiry in December 1929. And he says, and I quote, "The Palestine Mandate does not refer to the protection of the political rights of the Arabs, but refers only to the political rights of the Jews." And ever since then, ever since the 1920s, including all the way up until the present day, the Palestinians have made a variety of legal arguments in which they claim rights of self-determination in Palestine, the right to establish their own country in Palestine. Some Palestinians arguing that that includes the modern-day state of Israel, not just the West Bank and the Gaza Strip. Other Palestinians claim a right of self-determination limited to the West Bank and the Gaza Strip, but it doesn't matter because they claim one way or the other that they have an absolute legal right to establish their own state, separate and apart from any kind of political right that they may proffer. In addition, the Palestinians claim they're already a state because 130 countries recognize the so-called state of Palestine. If you look at the desk in the United Nations General Assembly where their representative sits, there's a placard that says State of Palestine. The International Criminal Court in February of 2021 recognized the state of Palestine, quote unquote, as a member of the International criminal court's governing document, the so-called Rome Statute. And the Palestinians, on the one hand, claim we want to be a state in the future. On the other hand, they claim they're already a state. So let's look at some of the responses to the Palestinian legal arguments. And what I'm going to do is take you up through the Oslo Accords, and then, time permitting, we'll look at some of the very recent activity post-October 7, 2023 at the international courts. Well, in response to the Palestinian arguments that I just showed you, there are many, many, many significant points that can be made, including the points I make in my book and many, many other important points that groups such as the UKLFI Charitable Trust have been making very effectively in the public arena. First of all, of course, during the 1920s and 1930s, many Palestinian lawyers and historians and witnesses before various tribunals repeatedly insisted that there was no such place as Palestine. Instead, they argued Palestine should be considered part of Syria. And the reason they made that argument was because they did not want the Palestine mandate to be allowed to continue with the creation of a Jewish state. The British government in 1937, with the so-called Peel Commission or the Palestine Royal Commission, and again with the white paper, the infamous white paper in 1939, offered statehood to the Palestinians in the part of Palestine that eventually became the State of Israel. 1937, most of Palestine offered to the Arabs, a tiny portion in northwest modern-day Israel around Haifa offered to the Jews. The White Paper of May 1939 offered all of Palestine to the Arabs. In 1947, November, the UN again offered the two-state solution, and every single time they were offered statehood in the 1930s and the 1940s, the Palestinians emphatically said no. They wanted everything or nothing, and they said no to the one-state offer in 1939 because the British offer would have required the Palestinians to wait for 10 years. They wanted it immediately, didn't want to wait at all. Well, after the War of Independence broke out, neither Jordan, which captured the West Bank, nor Egypt, which captured Gaza during the Israeli War of Independence, neither of those countries obtained sovereignty over the West Bank or Gaza. And to this very day, in 2024, there is absolutely no legitimate legal basis for either Egypt or the Palestinians or Jordan to assert legal title, final legal title over the West Bank or the Gaza Strip. In fact, during the 1948-1949 war, there were portions of Palestine allocated for the Arab state, which fell into Israeli hands. And the Arabs ever since have waived their claim to those portions, about half of what was allocated. And I'll show you that right here on the left. This is the two-state solution offered by the UN. The light blue areas there for the Jews, the dark brown areas for the Arabs. And you can see in the middle, this is a map that is available from the archives of President Harry Truman. The portions on the map here in pink falling into Israeli hands during the 1948-1949 war. And these areas in pink are what I'm talking about. The Arabs, the Palestinians, have irrevocably waived any claim to the areas in pink as a result of Israel capturing those areas in the 1948-1949 war, leading to the so-called Green Line boundaries that prevailed until 1967. Well, between 1948 and 1967, as I mentioned, Jordan occupied the West Bank, purporting to annex the West Bank, although only two countries, Britain and Pakistan, recognized the Jordanian annexation of the West Bank. Egypt occupied the Gaza Strip. And I refer in my book to this period between 1948 and 1967 as the period of the forgotten Jordanian and Egyptian occupations of the West Bank and the Gaza Strip. In fact, in Jericho, in December of 1948, several thousand Palestinian notables gathered in a conference, and they passed resolutions solemnly asking King Abdullah I to annex the West Bank and to make the Palestinians there citizens of the state of Jordan. That was an explicit waiver of Palestinian sovereignty, Palestinian statehood over the West Bank. And between 1948 or 1949 and 1967 during these forgotten occupations of Gaza and the West Bank. Not once during those 18, 19 years, let me repeat, not once did the Palestinians ever demand their own country, never demanded statehood in the West Bank and Gaza during the years of the forgotten occupations. The United Nations, not once during those years, demanded Palestinian statehood. The international courts, not once during those years, demanded statehood for the Palestinians. And even as late as May of 1964, when the original Palestine Liberation Organization was founded, it issued its charter. Even then, in Article 24, and I quote, the PLO saying that it does not exercise any regional sovereignty over the West Bank or the Gaza Strip, another explicit waiver of sovereignty over those areas. And here's an interesting document from February of 1964, 3 months before that PLO charter was issued when they met in East Jerusalem. This is a dispatch from the British Embassy in Amman, Jordan, to the Foreign Office in London. I found this in the British archives in Kew Gardens in London. And note the ambassador of the UK to Jordan saying in February of 1964 regarding this gentleman on the left, Ahmed Shukeri, Arafat's predecessor, the original founder of the PLO, that Shukeri's first statement on arriving in Amman was that there was no question of creating a Palestine Republic, as this would be meaningless, nor was there any intention of attempting to establish a form of Palestinian territorial sovereignty. Well, that was 1964. And if we advance forward to May of 1967, 3 years later, we all remember, and it feels eerily similar, by the way, to what is happening right now. Iran threatening to destroy Israel. In 1967, it was Egypt threatening to destroy Israel, massing troops along the border, joining forces with the Syrians to get the Syrian army to mass forces along the Golan Heights, expelling the UN emergency force from the Sinai Peninsula, which had been there as a buffer force since the 1956 war. And then 22 May 1967, in a blatant act of war, Egypt closing the Straits of Tiran, which it had bound itself to keep open in the 1949 armistice agreement with Israel. President Nasser repeatedly threatening in radio broadcasts to destroy Israel, to throw the Jews into the sea, etc., and then signing a defense pact on 30 May with Jordan, with King Hussein, and announcing that the Arab armies were ready to wipe out the state of Israel. And then, of course, against all of this, the Israeli Air Force, in a lawful act, let me repeat, lawful act of anticipatory self-defense under international law, struck an air base in Egypt, destroying most of the Egyptian Air Force on the ground. In response, Syria launched an unprovoked attack against Israel. Israel had not done anything to Syria. Same for Jordan. Israel begged King Hussein twice, please stay out of this conflict. We do not want war with you. King Hussein attacked Israel anyway. And in lawful defense of itself, only 6 days later, Israel replaced Jordan as the occupant of the West Bank, and Israel captured East Jerusalem and the Old City. Israel replaced Egypt as the occupant of the Gaza Strip until Israel withdrew in 2005, and Israel, of course, capturing the Golan Heights and the Sinai Peninsula. And a few months later, in November of 1967, the UN Security Council adopted Resolution 242, very famous, asking Israel to withdraw, quote, from territories, not all the territories, it's somewhat ambiguous, to withdraw from territories occupied in the recent conflict, meaning the June 67 war, which means, if you just stop there, that the Security Council recognized Israeli sovereignty over West Jerusalem, recognized Israeli sovereignty over the areas allocated to Palestine in the UN in November 1947 that Israel captured in the War of Independence that I mentioned earlier. And then in the bottom paragraph there, the UN Security Council demanding that all countries around Israel claiming belligerency or in a state of belligerency stop their warlike approach to Israel and acknowledge Israel's right to live in peace within secure and recognized boundaries. Now, many people on behalf of the Palestinian side say that this resolution 242 is the so-called land for peace formula. Israel has to give up the land first, and then the Arabs make peace. But you could equally read it the other way: peace for land. The Arabs must first make peace, and that isn't just Egypt and Jordan, but Saudi Arabia, Lebanon, Syria, Iraq, all the others. They have to make peace first, and only after they make peace would Israel be required to give up the land it captured in the Six-Day War. This resolution can be read equally either way. Now, I mentioned the Oslo Accords at the beginning, 1993 to 1995. Very, very important, as I said earlier, robust arm's-length negotiations between Israel and the PLO. The PLO obtained rights in the West Bank during an interim period, and until a permanent status deal could be reached, the Palestinians agreed in writing the West Bank would be divided into three areas: A, B, and C. A, the larger Arab towns, Ramallah, Nablus, etc. B, the smaller towns and villages. C would be the area that Israel would retain control over pending a permanent deal. Area C includes the Israeli settlements, and the Palestinians themselves agreed at Oslo that the Israeli settlements could remain in place. There is no restriction in the Oslo Accords about expanding or building new settlements within Area C, nothing. There's nothing in the Oslo Accords giving the Palestinians eventual rights to statehood or sovereignty. Instead, the PLO agreed that all of those remaining issues would be negotiated, that Palestine, the Palestinians, would pursue their claims through statecraft. And so when people today, on behalf of the Palestinians, claim that there is apartheid in the West Bank, I say nonsense. The situation in the West Bank today, the division into three areas, A, B, and C, reflects exactly what the Palestinians bargained for at Oslo. In fact, if anyone is breaching the division of the West Bank into A, B, and C, it's the Palestinians who have been making illegal construction activity in Area C. Here is the famous photograph: President Clinton, former Israeli Prime Minister Yitzhak Rabin, Yasser Arafat shaking hands. This was in September of 1993 when the Oslo Accords were signed. This map shows you the division that the Palestinians themselves agreed to. Area A in green, Area B in brown, Area C in gray. This is what the Palestinians negotiated for. Now, however, they want to back away, although they have not rescinded the Oslo Accords, and the Accords remain the governing legal document over the West Bank and including the Gaza Strip, if you will. Well, I mentioned Israel captured Jerusalem, East Jerusalem and the Old City in the Six-Day War in June of 1967. When the UN came up with their two-state solution in November of 1947, the idea was that Jerusalem would belong to nobody. The entire city would be treated as a separate body under international control. But as a result of the Israeli War of Independence, Israel ended up in West Jerusalem, Jordan ended up in East Jerusalem and in the Old City. And following the Six-Day War, as I mentioned, Israel captured East Jerusalem in 1980, passing legislation to formally annex East Jerusalem, as well as the fact that the 1994 Jordan-Israel Peace Treaty accords to Jordan, not the Palestinians, but to Jordan, administrative responsibilities for the Al-Aqsa Mosque and the other Muslim holy sites in Jerusalem. And so I conclude in my book that Israel's claim to West Jerusalem is rock solid. Israel's claim to East Jerusalem is stronger than the Palestinian legal claim to East Jerusalem, although neither party has absolute 100% sovereignty. But Israel's claim is stronger. The UN, for its part, over the years, has tried to morph Jerusalem from Arab territory, which it referred to in 1979 and earlier, from Arab territory into Palestinian and other Arab territory. And finally, the UN has morphed Jerusalem into solely Palestinian territory. But these resolutions really are meaningless. They're self-contradictory. The UN cannot award sovereignty over Jerusalem to the Palestinians simply by changing the wording in their various resolutions. And so my legal conclusions based on all this history are as follows. No one has absolute sovereignty today over the West Bank and the Gaza Strip, although Israel's claim to sovereignty over the West Bank and East Jerusalem is superior to the Palestinian claim. Israel, of course, withdrew unilaterally from the Gaza Strip in September of 2005 and does not purport to claim sovereignty over Gaza. Israel's occupation of the West Bank is not illegal. That's because the Palestinians agreed in Oslo that the Israelis could stay pending a permanent deal. Same story for the settlements. The mere duration of the occupation since 1967 does not render it illegal by any stretch. Jerusalem has never been, quote, Palestinian territory, as I mentioned earlier, and Resolution 242 requires the Arabs to make peace with Israel before Israel withdraws, and that is my legal position on 242. Okay, let me take about another 10 minutes or so just to talk about what has happened since October 7, 2023. This is a photograph of the inside, the interior of the International Court of Justice. You can see how opulent and ornate it is. And just to take you back to 7 October last year, to that horrible day, that terrible day, this map showing the Gaza Strip and some of the impacted areas. The yellow are the areas from which Israelis had to evacuate in the first months after the attacks. Some of the kibbutzim and other moshavim that were attacked on October the 7th. I want to just dispel a couple of myths about the Gaza Strip that you hear all the time in the media. First of all, many Palestinian supporters love to say the Gaza Strip is among or maybe the most densely populated strip of land on the face of the earth. That's absolutely false. Gaza Strip, 140 square miles, 2 million people, does not even make the list of the top 100 most densely populated areas on the planet. And any of you who have been to Mumbai or Delhi or Mexico City or Sao Paulo or Manhattan can tell you that those areas are far more densely populated than Gaza. As I mentioned, Israel withdrew completely from Gaza in September of 2005, handing the keys over to the Palestinian Authority. Hamas violently overthrew the PA in June of 2007, and ever since, Gaza has been under the iron-fisted occupation of Hamas, even though the International Court of Justice, in its recent advisory ruling of 19th July, just last month, said that ridiculously that Israel continues to occupy the Gaza Strip because it has effective control over Gaza. That's completely absurd. Think about how heavily armed Hamas was. Think about Hamas's attack of October the 7th. If Israel were occupying the Gaza Strip, of course, that wouldn't have happened. And the third myth is that Israel has an illegal blockade of Gaza. That's also bogus. A special commission appointed by, ironically, the UN itself, issued a report about 10 years ago, signed by the former Prime Minister of New Zealand and the former President of Colombia, the Palmer Uribe report, saying that the naval blockade that Israel had mounted against the Gaza Strip is perfectly legal under international law. And of course, most significantly, the southern border of Gaza is with Egypt primarily, and the Israelis have just discovered, just this morning, a tunnel connecting, we're not sure if it goes to Egypt, although it seems that it does, a tunnel 3 meters high, large enough for large trucks to drive through, delivering enormous amounts of weaponry and armaments to Gaza. On October the 7th last year, the worst day for the Jewish people since the Holocaust, I've often, as an American, asked myself, what if something similar were to happen against the United States? And look at the numbers here. If you just extrapolate to the US population and the size of the US. 1,200 Israelis murdered equates to 42,000 Americans. 200,000 displaced Israelis from their homes equates to 7 million Americans. 7,300 wounded Israelis equates to more than 250,000 Americans. 243 hostages taken equates to more than 8,500 Americans. Let me just pause and ask all of you, what do you think the United States of America would have done in response to a terrorist attack taking 42,000 American lives? Well, we know what the US would have done. Israel, of course, defending itself lawfully, responding in Gaza, defending itself against rocket attacks, missile attacks, drone attacks from Lebanon, from Iraq, from Iran, from Yemen, fighting on multiple fronts, attacks coming from or planned attacks from the West Bank. But the hostages really predominate discussion in Israel. I was there just a few weeks ago. On the left, you see the control tower at Ben Gurion with the yellow ribbon. On the right, the Tel Aviv Museum of Art. The plaza in front has been converted into hostage square. But the Palestinians and their supporters have mounted a relentless attack against Israel at the international courts. 3 cases at the courts. First, South Africa accusing Israel, and how dare they? How dare they accuse Israel of genocide at the International Court of Justice? The court has 15 members who serve for 9-year terms. This is as of February. A couple of them have been replaced. Here's the new American judge on the left, Sarah Cleveland, former professor of law at Columbia University with a very extensive list of anti-Israel publications to her name, posing there with probably the next president of the United States, Vice President Harris. In that case that South Africa brought, many accusations, unfounded, unverified accusations made by South Africa against Israel at the International Court of Justice, asking the court to order Israel not to violate the rights of Palestinians to be kept safe from genocide, if you can believe it. There were hearings at the court in January of this year. The South African lawyers, the Israeli lawyers, both making their arguments to the court. I got short videos, but I'm going to skip them here in the interest of time. I can show them later if you want. The South African lawyer accusing Israel of genocide, the Israeli lawyer, the incredible Tal Becker from the Israeli Foreign Ministry, making a very eloquent presentation refuting and rejecting the claims of genocide. The court, the ICJ, International Court of Justice, has issued 3 orders against Israel, 3 rulings since January, ordering Israel not to undertake certain activity in Gaza, as recently as May, not to invade Rafah, for example. Israel, of course, defending itself lawfully and not feeling bound by those orders. So that's the first case, the South Africa case at the International Court of Justice. The second case against Israel is at the International Criminal Court, where the prosecutor, a British lawyer named Karim Khan, on May the 20th announced that he is seeking warrants for the arrest of the Prime Minister and the Defense Minister of the State of Israel, arguing, for example, that they are responsible for using starvation of Gazan civilians as a weapon of war, and that they are deliberately targeting civilians in Gaza. Those allegations are unfounded, unsustainable, unproven. The starvation allegation, for example, was based on a March 2024 UN report. 2 weeks after May 20th, the UN issued an updated report saying, actually, there's plenty of food in Gaza. No one is starving. We need to continue to monitor the situation. We'll see if the International Criminal Court judges, who have the final say here, decide whether or not to issue these arrest warrants. But this is very, very risky, very dangerous, not just for these 2 individual Israeli citizens, the Prime Minister and the Defense Minister, but because the prosecutor works in secret, there could be other warrants for other Israelis in the future. This is a very slippery slope and very, very dangerous for the International Criminal Court to go down that road. And then finally, on the 19th of July, just a couple of weeks ago, the International Court of Justice issued an advisory ruling. The American judge I showed you earlier, joining the vast majority of the other judges on the court, ruling that the Israeli occupation of the so-called Palestinian territory in the West Bank is illegal, that Israel has to end the occupation as soon as possible, that Israel is under an obligation to cease all settlement activities, and that Israel must make reparations for the damage caused to all people in the occupied territories, in addition to the obligations that the court levied against Israel. And again, this is a non-binding advisory ruling. The court said all countries must not recognize the occupation as legal. The UN must not recognize the occupation as legal, and the UN should consider the precise means to bring the occupation to an end as quickly as possible. And while these courts have been busy devoting almost all of their attention to little tiny Israel defending itself, fighting for its survival, they have totally ignored Iran's massive drone and cruise missile attack against Israel last April. They've totally ignored Houthi attacks that have disrupted global shipping lanes through the Red Sea. They totally ignored the Houthi drone attack on Tel Aviv and Houthi missiles fired at Eilat. They've totally ignored Hezbollah rockets fired into northern Israel, displacing 80,000 Israelis from their homes. They've ignored Iraqi drones launched at Israel. They've ignored the fact that Qatar has been harboring the leadership of Hamas in Doha up until Ismail Haniyeh was eliminated last week, but there are other Hamas leaders still there under Qatari protection. The courts have completely ignored Egypt turning a blind eye or even facilitating arms smuggling into Gaza, and they have completely ignored the Palestinian Authority's so-called pay-for-slay program, paying money to terrorists who kill Israelis and Jews. So I'm going to stop there and take a breath. There's the cover of my book, and let me thank UKLFI Charitable Trust, Jacob, and all of you for having me back with you again today. Sorry for going so quickly. I'm sure there are a lot of questions, and I would love to hear your questions and comments. Thank you again.
Steve, thank you so much for that characteristically fantastic presentation, covering a huge amount of ground, but making your points with incredible clarity and force. I'd like to begin by asking a fundamental question, and this reflects some of the questions that the audience members have put. It's as follows. Why does the international law position matter at all? And this is a question which is often asked in Israel. It's often asked, particularly by non-lawyers. If all of these legal processes are stacked against us, then why does it remain important, if that is your view, to continue to engage with these legal arguments?
It's a great question. It's very important that we continue to engage. The Palestinians and their supporters are trying to use the international courts to delegitimize Israel, trying to use the international courts to turn Israel into a pariah state, much like apartheid South Africa, even though Israel has nothing to do with apartheid South Africa. But that's what they're trying to do, the opponents of Israel, with these legal cases. The consequences could be severe for Israel in the international banking system, for example, in terms of trade agreements with the European Union and other countries. That's going to be the next step from the Palestinians and their supporters. They're going to try to use these opinions, even though they're not binding, the advisory opinion, the arrest warrants, if they get the arrest warrants for Netanyahu and Defense Minister Gallant, the Palestinians and their supporters will then go and try to market these opinions, if you will, as part of their delegitimization campaign against Israel, and try to force or pressure entities in the global economy, the global trading system, to break ties with Israel, to prevent Israel from accessing those systems, to break diplomatic relations with Israel, to continue to tighten the noose around Israel, if you will, in using much the same playbook as we saw with respect to South Africa some 40 years ago.
There is a related question to that, which is something that you picked up on in your presentation. Israel chooses to engage with certain of these international legal processes, for example, with the recent ICJ hearings on South Africa's referral under the Genocide Convention. And you mentioned the fantastic work by by Advocate Tal Becker and others. And it may well be the case that those presentations led to the ICJ's interim rulings, not really hampering Israel's just prosecution of the conflict in Gaza. But what about the other legal processes that Israel doesn't choose to engage with? For example, the recent ICJ advisory opinion, where it simply doesn't wish to give the court the legitimacy of having Israel stand before it. Is Israel striking the right balance here?
Yeah. Before I answer that question, I've seen a couple people asking if they can have my slides. Absolutely, yes, of course. And I will send them to UKLFI Charitable Trust, and they can distribute them to you as they see fit. But you're more than welcome to my slides. Why didn't Israel participate in the advisory ruling proceeding? There was a separate advisory ruling proceeding 20 years ago in 2004, raising the question whether the Israeli security barrier, the wall of separation, was or was not legal. The court in that case issued an advisory ruling in very short order. Of course, it was against Israel. Israel knew that would be the outcome. They didn't really feel it made any sense to devote resources. Again, we're not talking about a legal operation in Israel the size of what we have in the UK or the US. Israel has to decide carefully how to allocate its resources. And knowing that the advisory rulings are not binding, that the advisory rulings don't really have the kind of precedential impact in terms of binding countries, Israel elected not to participate. I don't want to speak for them. I'm not privy to any internal discussions among the Israeli Justice Ministry or Foreign Ministry as to why they chose not to participate in those cases. On the genocide case, of course, shocking that anyone would try to weaponize the term genocide, weaponize the Holocaust, the Nazi Holocaust of the Jews against the state of Israel. Shocking, shameful, and perfectly understandable that not only would the Israeli government mount a defense, but the Israelis also had the option to name a judge to sit as a member of the court just for purposes of that case. And the Israeli government appointed Aharon Barak, former president of the Israeli Supreme Court, High Court of Justice, to play that role. And of course, he dissented from the various rulings that I showed you there in January and March and May.
A questioner from the audience asks, would the situation be different now if Israel had declared full sovereignty less than 10 years over Judea, Samaria, Gaza, and the Golan?
Not sure. In the face of Resolution 242 in November 1967, it would have been difficult for Israel to sustain a claim of sovereignty over Judea and Samaria. There is a legal theory that has been put forward by Professors Bell and Kantorovich that says that under the principle of uti possidetis juris, Israel, as the only state to emerge from the Palestine Mandate at the end of the mandate on 14 May 1948, Israel inherited the boundaries of the mandate, the British mandate, meaning all of the West Bank, all of Gaza, all of the modern-day state of Israel. There is great controversy over whether or not that principle of international law conferred sovereignty over those areas on Israel as of the end of the mandate. I would also mention that the Israeli government, while maintaining and reserving all of its rights, has agreed, and so has the Israeli Supreme Court, that the provisions of the so-called Hague Regulations of 1907, that Israel is honoring those as the occupant of the West Bank, at least with respect to humanitarian issues regarding the local population. Israel has not conceded one way or the other whether it does or does not have sovereignty. That's an issue that Israel has reserved since the April 1949 armistice agreement with Jordan. The reservation of rights is right in that agreement. Jordan agreed to it. Israel's reservations of rights continued in the Oslo Accords and in the Israel-Jordan Peace Treaty. So that's why I say that as we sit here right now, legal title, if you will, the deed, who has the deed, the property deed, the title deed to the West Bank, that's an issue that is really, really unsettled, up in the air. That's why the position of the Israeli government is that that issue must be resolved through negotiation and statecraft, not litigation.
Another question from the audience. The questioner asks, you referenced at the beginning of your presentation one of the Palestinians' arguments that they have been recognized by other states. And this person says that they are perplexed by the recognition of Palestine by other Western states, for example, Ireland. And they ask, what effect, if any, does this have? Can a
Yeah,
state be recognized without defined borders?
yeah.
And so on. And does that mean that these recognitions are purely symbolic?
Great question. Answer, they are purely symbolic. There is an international agreement from 1933 called the Montevideo, Uruguay, Montevideo Convention that says that statehood depends upon control of territory, full ability to conduct foreign relations, etc. Palestine flunks that test. Every international scholar who's written about it agrees that Palestine flunks that test. Mere recognition alone is not sufficient to confer statehood legally. And so when Ireland and Norway and Spain recently recognized the existence of the state of Palestine, purely symbolic, no lasting legal effect, but it does give the Palestinians a lot of PR momentum and a lot of other wind behind their sails when it comes to trying to claim that they are in fact a state, which of course conflicts with their other claim that they're entitled to statehood at some point in the future. But putting that aside, it gives the Palestinians a lot of momentum in the public relations realm.
Another person asks, is it beyond the powers of any organ of the UN to recognize the West Bank, East Jerusalem, and Gaza as having any status other than as Israeli territory by virtue of a concept that you mentioned earlier, utai possidetis juris, lest the Charter of the UN be found in conflict with what they describe as the peremptory norm of international law that prohibits recognition of a situation brought about by an aggressive war, namely the aggressive war or wars of the Arab states against Israel?
Yeah. Um, Another great question. My contention is that the United Nations lost all jurisdiction, legal jurisdiction over Palestine upon the termination of the mandate on 14 May 1948. I've maintained that position for years. The UN has no legal authority to come in today and award sovereignty to the Palestinian Authority, to Hamas, to Palestinian Islamic Jihad, or to anybody else over the West Bank and the Gaza Strip. And the Palestinians themselves agreed in the Oslo Accords that any future disposition of those territories would be the result of face-to-face direct negotiations with Israel. Why should Israel ever sign another agreement with the Palestinians like Oslo if the Palestinians are going to turn around and ignore it, continue to pay terrorists, continue to teach their kids hatred in school, continue to act as if they already have statehood? Why would Israel ever sign another agreement with the Palestinians if the Palestinians are going to ignore it? And I do want to also, Jacob, acknowledge the very important point the questioner made. November 1947, 29 November, the UN passed by the requisite two-thirds majority, the partition plan, the two-state solution. The Jews in Tel Aviv reacted by dancing in the streets. We've all seen the photos of that. The Mufti reacted by stirring up a civil war, which began the next day, 30 November. 6 months later, Ben Gurion went to the art museum on Rothschild Boulevard in Tel Aviv and read the Declaration of Independence. And the next morning, the Egyptian Air Force was dropping bombs on Tel Aviv. And the armies of Lebanon, Iraq, Syria, Egypt, and so forth all invaded, trying to destroy the new state. When I was in Israel 3, 4 weeks ago, many people I spoke to said, today, post-October 7, feels a lot like it did in 1948, 1949. We are fighting for our survival. We didn't attack anybody. We didn't want war with anybody. We didn't then, and we don't now. But we're fighting for our survival against those who have unprovokedly, if I can say it that way, launched war against us.
We have another question which is related to the situation as it stood in 1948, but how that goes on to affect the situation now. And the question asked quite simply, could you talk about Article 80 of the UN Charter? And for context, this is sometimes referred to as the Palestinian article, owing to its potential impact on the status of Israel and rights of people before that. But the question asks, how does that interact with your views?
Doesn't really impact my view at all. Again, the Palestinians agreed in Oslo to a specific framework, to a specific understanding, legally binding understanding with the Israelis, which trumps anything to the contrary. Article 80 or the UN resolution from 1960 that proclaims self-determination as a fundamental international right, erga omnes. If a party agrees in writing to the legal equivalent of a treaty, and under the Vienna Convention of the Law of Treaties, the Oslo Accords have the legal status of a treaty, even though Palestine, the PLO, wasn't a state. The Article 3 of the Vienna Convention is very clear that this kind of agreement between a state and a non-state actor is an enforceable, binding legal agreement. Then that's the controlling document, not Article 80 or anything to the contrary.
Turning to another area where I know you've written at length and done some extremely important research, that is the status of Jerusalem, and in particular the holy sites of Jerusalem. One of the questioners asks, can the designation of who controls the Temple Mount be legally challenged?
Well, it depends who designates, who makes that designation. Control of the Temple Mount, in my view, is first and foremost a subject for the Israeli and the Jordanian peace treaty, which addressed the special role of Jordan as custodian of the Muslim holy sites on the Haram al-Sharif, the Arabic term for the Temple Mount. And even as recently, by the way, as the spring of 2022, there was a four-part statement issued by the U.S., Jordan, the Palestinian Authority, and the Israeli government, in which the Palestinians agreed to the special custodial role of the Jordanian government over those sites. Down the road, Jerusalem is identified specifically as one of the final permanent status issues in the Oslo Accords to be negotiated. Down the road, through negotiation, if the Israelis and the Palestinians and the Jordanians agree on a particular way forward for the Temple Mount, so be it. There is a very strong evidence that in 2008, when former Prime Minister Ehud Olmert offered on a napkin a drawn map for a peace proposal to Mahmoud Abbas, Abu Mazen, there is strong evidence, and including Olmert's own statement, that Olmert offered or maybe floated the idea, we're not sure how firm the offer was, but at least floated the idea that the old city would become internationalized. The old city, of course, with guarantees for Jewish access to the Jewish holy sites, never went anywhere because, like his predecessors, Abu Mazen said, I want everything or nothing. I will not compromise. I will not negotiate, unfortunately.
Someone else in the audience asks or comments this. You argue that the occupation is legal, but the court, by which I understand them to mean the ICJ, decided that it is not. How can that be explained? Is it a matter of opinion or fact? And when I read this question, I thought of the analogy that's often used by US judges that I'm sure you'll be familiar with, Steve, to describe different approaches to law. And they imagine judges as three types of baseball umpire, calling whether throws are good. One umpire says, I call it as it is. The second umpire says, I call it as I see it. And the third umpire says, it ain't nothing till I call it. So for those who view international law as what international courts say, how do we answer the argument that the international court has ruled against Israel, therefore that's the position?
So they have a fourth view, which is we call it the way we want to see it. This court, the International Court of Justice, and I know I'm being recorded, but I will just offer my own personal opinion on my own behalf. This is a United Nations entity. The International Court of Justice is found, its founding document, its statute is part of the United Nations Charter. It is a creature of the UN. Its predecessor, the Permanent Court of International Justice, was a creature of the League of Nations. So let's start with the proposition that this is a UN court. The presiding judge of the UN court is from Lebanon. Last time I checked, Lebanon was a Hezbollah-controlled country. And this presiding judge has tweeted and written extensively about Israel, and you can imagine what he has said over the years. You can only imagine what he has said over the years about Israel. There is only one judge on that court out of 15 who said anything positive about Israel in this recent advisory opinion, and that was the Ugandan judge, Judge Sebutinde, who has now been ostracized in her own country for daring to speak the truth about the history, some of which I shared with you, and the law. It is, to me, a tragedy, a travesty of justice that judges who have taken a public position regarding a case pending before them would not recuse themselves, would not say, I've written extensively about this. I have a particular view. I should not sit in judgment in this case. That would be the rule in the UK or the US or pretty much anywhere else in the Western world. And these judges at the International Court had no hesitation. I'm anti-Israel. Oh, here's a case about Israel. Guess how I'm going to rule? So you can tell, am highly critical of the way the court has carried out its obligation to do justice. And I think that there's another very important point that I want to make about the court. The court is now kind of swimming outside its lane a little bit, or a lot, purporting to tell Israel how to conduct its war of self-defense in Gaza in 3 different rulings in the South Africa genocide case, or engaging in ridiculously nonsensical language in its recent advisory ruling in which it said that Israel is still occupying Gaza. How anybody could say that is beyond me. And I think what we're seeing here structurally, fundamentally, is that the court is trying to occupy the province of the UN Security Council. In other words, at the Security Council, the United States has a veto. And most often, not always, of course, but most often has used that veto to protect Israel against adverse Security Council resolutions. And so the Palestinian lawyers and their supporters have said, let's forget about the Security Council. Let's go to the International Court of Justice and see if we can get them to engage in the kind of policy making and political decision making that ought to be the sole province of the Security Council. And the court has welcomed the opportunity to play a larger role on the world stage, to pronounce on political issues and issues of war and peace and security, when traditionally the role of the court is to decide boundary disputes between Chile and Peru, for example, and not to play the kind of role that should be reserved solely to the Security Council. And that is a very, very, very worrisome development.
We've had an enormous amount of questions, and there's been a huge audience joining us this seminar. I'm so sorry we haven't been able to get to all of those questions, but there is one final one that I'd like to put to you, Steve, as I think it is an important one for all who watch this, and that is another from the audience. Is there anything Israel is not doing that it should be doing to better defend itself in the legal realm? And is there anything that Jews dispersed outside Israel can do to help support Israel in this way?
Yeah. Okay. Let me take the second half of the question first. There is so much that we can do. Many of you are doing, and I want to commend those of you who have been working so very, very hard to defend Israel in the public opinion arena, on social media, and elsewhere. So many of you are working so hard, and I am a great admirer of all the terrific work you are doing and UKLFI Charitable Trust is doing. Look, I think that the more that we can, first of all, talk to our own people in the Jewish community in the diaspora, because there are many young Jews in the diaspora who are very iffy about Israel, we need to get them on side. So let's start with our own community. Then let's work outward from there. And whether it's submitting articles to your local paper, whether it's writing letters to your elected representatives, if you're in the U.S. or in the West, or even in the case of some of us, if you're lawyers working together with other lawyers who have an interest, UKLFI Charitable Trust, the International Association of Jewish Lawyers and Jurists, many other lawyer groups are doing terrific work here because we need to be prepared for what is waiting us down the road. And that is, as I said earlier, an effort to try to leverage these international rulings to ostracize and delegitimize Israel and to deny Israel access to important international arenas and institutions. So very, very important we do all that. Let's, by the way, continue to keep the pressure on the BBC, on the Washington Post. All of you who are involved in that effort are doing a great job of calling out lies and falsehoods that we see in the media all the time, trying to promote the anti-Israel narrative. As far as the Israeli government itself, I just want to say that the lawyers at the Foreign Ministry, led by, at least until recently, Tal Becker, the lawyers at the Ministry of Justice, they're fantastic. They're fantastic lawyers. I don't work for them. I am on my own, independent here in California, but I know several of them very, very well, and they are of the highest caliber. They're superb lawyers. They've done a terrific job over the years. And I would point no further than the Turkish flotilla case. You maybe remember about 10, 12 years ago, a Turkish ship called the Mavi Marmara that tried to break the Israeli naval blockade. Getting to Gaza, the Israelis offered the ship to disembark, offloaded supplies at the port of Ashdod. They refused. There was a conflict, and the Israeli lawyers did a wonderful job persuading the prosecutor, the then prosecutor, Fatou Bensouda at the International Criminal Court, not to pursue charges. So Israel is blessed with wonderful, wonderful lawyers. And those of us in the diaspora, whatever we can do on our own to help in our communities, let's keep doing it. And I really admire all of you for your wonderful efforts. Let me say one last thing before Jacob signs off. Many of you, I've been looking at the chat, have asked fantastic questions. And I would be happy to respond to those individually. If UKLFI were to get those to me, I'll be happy to respond to as many as I can in writing. Thank you all very much. Thank you, Jacob.
Steve, thank you so much again for that brilliant presentation and your insightful answers. Thank you also to everyone in the audience for participating and for the excellent questions. I've seen over 60 questions being asked, which is a testament to the level of interest in your work, Steve, and also to the level of engagement from those watching. I'm so sorry again to those whose questions we didn't reach, but Professor Zipperstein has kindly offered to respond by email separately. His book is available from the Routledge website or Amazon, indeed his books, plural. And as a reminder, the latest one is called The Legal Case for Palestine, A Critical Assessment. If you'd like to hear this webinar again or are recommending it to your friends, it will be posted on the YouTube channel of the UKLFI Charitable Trust. This webinar is free, but if you would like to contribute to the UKLFI Charitable Trust's work, you can do so at the website, uklficharity.com. Thank you all again.
Thank you.